Have you ever wondered why fashion houses lose their minds when someone decides to copy their design? Well, if you think fast fashion knockoffs are a recent problem, think again, because knockoffs are not a recent issue. In fact, the fashion industry has been a lawless wild west of stolen ideas, anonymous designers, and corporate espionage for over 2 centuries. So, how did we go from a landscape that had no protection whatsoever to a series of protections that provide a multi-billion-dollar legal shield? Let's unbox the chaotic and also dramatic history of fashion intellectual property law in the United States. Let's get into it, shall we? Before the United States even came into existence, and there was a single law in the books about copyrights, patents, and trademarks, the original copycats weren't operating out of a massive factory. In fact, they were operating in the narrow streets of London and driving the British Empire entirely insane because of the fact that they were stealing just so much. You see, the foundation of American law is deeply rooted in the combination of American common law and acts that were passed by Parliament. And so as a result, if you are a garment designer or a textile manufacturer, you were completely exposed prior to 1787. As a result, there was no substantial legal scheme to protect your work, and if there is no scheme to protect your work, there is nothing but total, unadulterated intellectual property theft. Designs were stolen constantly, so as a result, the issue became so severe that many brilliant designers remained completely nameless, or their identities were swallowed up in the market and they would never be able to claim credit for their design. And while these designers hailed from many parts of the world, some of which spawned the entire expanse of the British Empire, mainland Europe, and Asia, only domestic textile manufacturers were able to actually get rich off of these designs. Copycats were getting rich off of the fledgling textile trade, and they were using methods that original artisans had come up with without giving them any sort of credit or putting in any sort of creative grunt work. But Parliament got irritated and decided enough was enough. So in 1787, they passed the Designing and Printing of Linens Act, famously known as the Calico Printers Act. The Calico Printers Act was a game changer. It was arguably the first modern intellectual property law passed in the Anglophone world that explicitly protected textiles. And here's how this worked. First, it protected newly developed printing patterns for a total of only 2 months. It also covered only 3 areas of fabric: cotton, muslin, and linen. And then last, you had to actually claim your rights using a very peculiar method because you had to print your name on the bottom of the end of the fabric bolt, identifying that you were the one that originally came up with the design. Now, this original system, had its issues with it and they had to expand it. So in a few years later, in 1794, they expanded the protection from 2 months to 3 months. And then further expansions took place in 1839, where the act was expanded to cover wools, silks, and hairs, while also being able to allow for protections for 3-dimensional design components and elements. This laid the foundation for modern American fashion IP law as we know it. Across the ocean, the year is 1776, and the ink on the Declaration of Independence is still fresh and has not dried yet. And the brand new United States already has a massive problem because they have no federal scheme that governs intellectual property laws. As a matter of fact, it was just a literal free-for-all for anyone trying to build a business. So when the United States did declare independence from Great Britain, a unified IP system was nowhere to be found. Under the Articles of Confederation, there was very little federal oversight. Individual states were able to run their own shows, transacting business in whatever way they saw fit, drafting up treaties and contracts in whatever way they saw fit, and even creating their own currencies. There was no federal scheme that was meant to provide national protection also for intellectual property. So if you wanted any sort of intellectual property protections, you had to hope that your local state law had it. And some states, like South Carolina, which became the first state to create its own IP protection laws in 1784, did actually put them on the books. But everything shifted in 1787 when the Constitution established the first true federal government. And along with it, the framers knew that if they wanted the United States to be a hotbed of innovation, they had to find a way to protect ideas. So as a result, they baked in an intellectual property provision directly into the Constitution, into Article 1, Section 8, which states the Congress shall have power to promote the progress of science and useful arts by securing the times to authors and inventors the exclusive right to their respective writings and discoveries. With that, the American Industrial Revolution began to start revving up, and the young country was suddenly crawling with inventors eager to build and invent. But they still needed a legal shield. Congress heard the cry and moved very, very quickly. And so they passed the Patents Act on April 10, 1790, and quickly followed up with the Copyright Act on May 31st, 1790. So let's first talk about the first Patent Act of 1790. The act was groundbreaking but a headache. You see, it was permissive because any citizen or even an enslaved person could file for a patent so long as your invention was new and useful. And also, you could lock that down for 14 years. But there was a catch. The catch was that presidential cabinet officials had to appoint the patent. So imagine your Secretary of State needing to look through your application in order for you to get your patent approved. And as you probably would suspect, it created a massive backlog in the system. By 1793, Congress had to amend the law because the cabinet was too busy trying to run a new country. And so as a result, they didn't have the time to look at patent blueprints. So the law was changed in 1793 to loosen the rules, cut the red tape, and then hand over the review process to clerks who could review the application and then issue a patent number. The thing that also made the 1793 version of the Act special was the fact that it also barred foreign nationals and also those Americans who stole from foreign sources of any sort of design. So basically, if you tried to file a patent as a foreign national, or if you were an American that tried to file a patent that was stolen from another country, you were not able to get your patent. The creation of this system really helped to set the groundwork for inventors to start creating. And by 1807, they started to have 100 new patents filed annually. If you thought that the first major garment breakthrough came from a textile mill, think again, because it came from a lone woman in New England weaving straw, silk, and thread together to create bonnets and hats. Mary Kies in 1809 became the first woman in American history to ever receive a patent in the United States. What was her invention? A highly stylized weaving method that combined silk, thread, with straw to construct hats and bonnets, which were all the rage at the time. And that timing was perfect because in 1807, President Thomas Jefferson had enacted a sweeping embargo on goods coming out of the United Kingdom and parts of Europe, severely choking the supply of imported textiles and finished goods. In America, they needed some domestic fashion fast. So Kies' innovation method stepped right into the void, allowing her to start making hats and bonnets and earning praise from First Lady Dolly Madison and proving to the government that garment construction is a vital and useful art worthy of patent protection. Now, tragically, however, you cannot see Kies' original patent. Why? Well, it's because it was an X patent, and many of those X patents that were filed prior to 1836 were lost in a fire that destroyed the Records Patents Office in 1836. So despite her genius, Mary Kies unfortunately was never able to see a fortune from her invention, and she passed away completely impoverished. But her legacy continues to live on as, again, she is the first woman to ever hold a patent in the United States of America. If you think that the most revolutionary pre-Civil War fashion patent was the sewing machine, well, you'd be incorrect. And also you'd be missing out on a brilliant black tailor who invented an entirely new industry, which is one that you actually still rely on when you want to get sharp and looking snazzy. Most people assume that the sewing machine was America's first big garment patent, but that actually isn't the case. Elias Howe didn't secure that invention or that patent until 1846, and that was long after the English had patented their own version of the sewing machine in 1790. Actually, the real pioneer of early garment care was a free black man by the name of Thomas J. Jennings. Born free in New York in 1791, Jennings was a master tailor in the city's early elite. And he kept running into the same problem that you and I still run into today: tough stains, grease, and smudges that were constantly ruining his clients' clothing. Instead of throwing his hands up, however, Jennings decided to craft a solution for the solution. He filed a patent in 1820, and on March 3rd, 1821, he was awarded U.S. Patent number 3306X for a process called dry scouring. You see, dry scouring is the direct ancestor of modern dry cleaning. The concept was brilliant. Jennings would apply a specific series of chemical solvents to the surface of a garment without a single drop of water, and then those solvents would dissolve and lift stubborn stains and dirt. Then, following that, heat would be applied to safely evaporate the solvent and any remaining chemicals. Now, while the exact chemical composition or the formula remains a secret and now also is completely lost to time due to the fire of 1836, his reputation of erasing impossible stains made him legendary and made him extremely wealthy. Jennings then used the wealth generated from his invention to do something powerful. He heavily funded abolitionist causes, and that activism continued to run in his family because his daughter, Elizabeth Jennings, would help spearhead the desegregation movement of New York tramcars. As we get closer to the American Revolution, the legal landscape did get a little bit volatile, and in 1858, just a year before Jennings had passed away, the court ruled in Oscar Stewart versus Ned that enslaved people could not legally hold patents, which was a complete reversal from the Patents Act prior interpretation. In a bizarre historical twist, however, the Confederacy actually passed their own law in 1861 allowing enslaved people to hold their own patents. Now, Jennings did pass away a few years shy of the Emancipation Proclamation, but his 200-year-old technological contribution to the fashion maintenance industry remains virtually unchanged to this day, in this side of the world all the way around to the other side of it. Now, onto the matter of trademarks. Have you ever wondered what the oldest clothing trademark is in the world? I'll give you a hint. It's probably sitting in your closet, and it's probably stitched into a pair of blue jeans that were originally invented for miners and also cattle herders out west. Well, I'm going to tell you, trademarks are a late invention to the American IP scheme, and a true federal trademark system didn't exist until 1870. Prior to that, individual states actually handled trademarks, and those trademarks only went as far as those states' borders. The federal government did step in 1870 to create the Trademark Act, but the Supreme Court struck that law down in the trademark cases of 1879, where the court argued that Congress didn't have the authority to actually create laws of this type, because under the Patent and Copyright Clause, trademarks didn't fall under that. And also, the law as written would violate the Commerce Clause. So not long after the trademark cases were ruled on in 1879, Congress went back to the drawing board and came up with the Trademark Act of 1881. But this Trademark Act of 1881 was relatively weak because it only protected marks that were used in international commerce or within Native American tribes. This meant that domestic interstate commerce was completely unprotected and unregulated until the massive overhaul in 1905 and further supported in 1946 with the Lanham Act. There is one legendary brand that knew exactly how to leverage this change, though: Levi Strauss. Levi Strauss actually started with a utility patent in terms of helping to secure their intellectual property rights. On May 20th, 1873, Levi Strauss and a Nevada-based tailor named Jacob Davis were granted the U.S. patent number 131,121 for improvement in fastening pocket openings using copper rivets. This moment is officially coined as the birth of the blue jean, and it was given the code name XX. They also stitched a distinct bow-shaped pattern or design onto the back pockets, which also has been used continuously since 1873, making it one of the oldest active clothing trademarks on Earth. As far as Levi Strauss, however, they were aware that that rivet patent would expire by 1887. So they decided to go back into the lab and see exactly what they could come up with. Immediately afterwards, they then decided to create a trademark and filed under the new trademark law. So in 1886, the trademark featured two red horses trying to pull a pair of jeans apart. Levi's was a classic Western brand operating also in Western states, and they also heavily sold in Native American territories, which meant that they would qualify for the restrictive 1881 federal trademark protection. But it was a genius legal play on their part because they were able to be one of the first companies to secure trademark protection under the American intellectual property scheme. And 140 years later, that two-horse mark still is there today. And even then, they've even stacked newer trademarks to protect their brand identity even further, including the red tab sewn onto the back pocket introduced in 1936. It's important to realize that the American intellectual property scheme is still developing and is still relatively young, but it's grown in line with the country. And it's important to also realize the next time that you do see a fashion brand suing over a logo or a unique pattern, it isn't necessarily about corporate greed, but more so the evolution of the legal battleground that started with hand-woven straw bonnets or copper-riveted denim, or even processes that involve the cleaning of our clothing. And today, the fashion legal machine is massive because roughly 1,000 to 1,500 patents are filed annually now for apparel-related items. Some of them also are design patents protecting aesthetic silhouettes of a piece. Others are utility patents that are locking down advanced manufacturing mechanics or cutting-edge synthetic fabrics that are composing of specific chemical compositions. But in American history, however, these legal protections have quietly revolutionized how we dress, how we build brands, and how we navigate the modern consumer world. They've safeguarded the creativity of visionary designers, generated hundreds of billions of dollars in the process, and as a result, we can't just say that these are just fly-by-night circumstances. Fashion isn't just art anymore. It's also serious law, too. So if you love this deep dive into the hidden legal history of style, please hit that like, share, subscribe button. Drop a comment below. Let me know what your favorite piece of fashion history is or what you thought from this video was interesting, and I'll see you in the next one. Toodles.